Welcome to Time is Not on Your Side with your host, board-certified litigation attorney Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now here's the host of Time is Not on Your Side, Rob Eckard.
Welcome to another episode of Time is Not on Your Side. I'm your host, board-certified business litigation attorney and government investigation specialist, Robert Eckard. Today's topic is effectively mediating complex corporate disputes in litigation between officers and directors of a corporation or a limited liability company. Claims against the corporate officer or director most commonly are derivative claims brought on behalf of a corporation or a limited liability company in which the company is a nominal plaintiff. These claims typically allege that the defendants have breached their fiduciary duties. Fiduciary duties include the duty of care, the duty of loyalty, and the duty of oversight. Most of us are familiar with the fiduciary duties of duty of care and loyalty. However, on January 26, 2023, in a Delaware case, in Ray McDonald's Corp. Stockholders derivative litigation, the Delaware court for the first time explicitly acknowledged that the duty of oversight by officers and directors. The duty of care. One of the fiduciary duties that is typically alleged to have been breached is the duty of care. Directors and officers of an entity act as fiduciaries and must act as reasonably prudent people in their positions would. Whether a director or officer has met this obligation is assessed against the business judgment rule. So long as the fiduciary makes the decisions which show sound judgment based on the information available at that time in good faith and without any conflict of interest. Courts generally don't second guess those situations. To do so would be kind of looking behind the curtain. Courts don't like to do that. The duty of loyalty. The other fiduciary duty typically alleges to have been breached is the duty of loyalty owed to the company and the shareholders under state or common law. The duty of loyalty is the obligation to be loyal to the entity, acting without a conflict of interest. Corporate conflict of interest can occur, and it has to be noticed to the board of directors and dealt with. That interested person must abstain from voting on such a matter. The breach of fiduciary duty claims can be either common law or fiduciary, and they can be direct or indirect against the company. However, in Florida, a state court litigation case, Haas versus Roe, a second district court of appeals case, the court held that a plaintiff shareholder may not bring both direct and derivative claims in the same case. If that happens, a claim for misjoinder would be subject to a motion to dismiss. So today's podcast will focus on derivative cases, and especially those involving the culpability of claims and personal exposure and insurance coverage. Mediating derivative claims requires an understanding of the applicable law, corporate law, and the nature of the claims and positions of the defendants of each defendant and indemnification rights, the company's view on the merits of the claims, and the amount of creditors and officers, director and officer insurance in primary and excessive coverage policies, and the possibility of liability, the insured in excess of policy limits. In the mediation, there will be counsel for the plaintiff, who must be a shareholder. There'll be counsel for the company, counsel for each of the defendants, and counsel for each of the insurance carriers. Derivative claims against officers and directors are generally brought by a named shareholder or a limited liability company interest holder. Although in Delaware and in some other states, creditors can bring the claim if the company is insolvent, but the company is always the nominal plaintiff and the action seeks to recover for the company. The company, of course, can make decisions and act only through its officers and directors. As an initial matter, the company will normally deny the validity of the claims, but its position as the beneficiary of any recovery must be understood as negotiations for settlement begins. In addition, there may be tension and disagreement among directors and officers, especially if board members and officers have been changed since the time of their alleged wrongdoing. Similarly, the defenses and positions must be carefully considered. Under current Florida law as well as Delaware law, and in most states, all can be exonerated from liability for breach of the duty of care in the charter or shareholder agreement, but it is possible that some will not be. If the claims are for breach of the duty of loyalty, they cannot be protected from liability, but they can be exonerated from liability for all duties if it's under the limited liability company operating agreement. So for each of the defendants and the beneficiaries of the transactions or relationships, you have to understand who is to the benefit and the duty of loyalty issues. Some officers and directors may be concerned about negative publicity for the company and themselves if the case moves forward. Another factor for the mediator to consider is to take into account the status of the case. Motions to dismiss will have been filed on both the complaint as stated valid claims and whether pre-suit demand has been made or exercised under the doctrine of futility. The demand for futility doctrine is closely tied to potential liability of the defendants. Before a derivative complaint can be filed under state law, the shareholder must make a demand on the board to bring the claim unless the plaintiff can show a demand it would be futile. If demand must be made, the case is usually dead on arrival because the courts don't second guess the decision by the board that the claim should not be brought. Futility is present where the plaintiff can plead facts showing that the majority of the board is conflicted because of the potential liability under the claims or close personal relationship with the controlling shareholder. Thus, the status of motions to dismiss will have a huge effect on the view of the parties of the value of the claims. In any derivative case, the status and amount of D&O insurance is the utmost importance, and counsel for the carriers and carrier reps are key players in the negotiations. D&O insurance typically has 3 levels of coverage. We have Side A, which provides direct coverage for directors and officers for the defenses and liabilities. Side B, which reimburses the company for amounts the company pays under indemnification obligations owed to the directors and officers. And Side C, or entity coverage, which covers the insurance corporation and its right for certain claims such as security class actions. Now, the issues to be understood include the rate at which the attorney's fees for the multiple defendants in this case and the fees and exposure in other cases fall under the same policy limits, such as parallel securities, class actions, or eroding coverage. 2, whether the policy could become part of a bankruptcy case for the company if a bankruptcy becomes an issue. 3, whether the Side A coverage has standalone coverage. And 4, whether the carrier has denied coverage or reserved rights under policy exclusions. Issues can also arise between the primary and excess D&O carriers. For example, a primary carrier may take the position that it will not fund a settlement without the primary policy limits, within the policy primary limits, only if the excess carrier contributes some of the amount, arguing that if the case is not settled, the current recovery could easily exceed the primary policy limits, and the excess carrier should have to pay for the elimination of that exposure. Finally, it is also possible that defendants who want to settle within policy limits and are concerned about the personal exposure under a large verdict will consider a bad faith claim against the carrier that will not agree to a settlement, creating a difficult position for defendants, attorneys, and those being paid by the carrier. A mediator in a derivative case thus confronts the situation with multiple parties and attorneys, a playing field that the lines are constantly changing. An understanding and appreciation of the issues and concerns for all parties, and the fact that the issues between the defendants themselves, defendants and carrier, and among carriers are fluid, thus the unusual situation for the company, are essential. A mediator with such knowledge and experience is in a position to help the parties reach a resolution is in the best interest for everyone involved. This has been another episode of Time is Not on Your Side. Please hit the like button and subscribe on all social media platforms such as LinkedIn, YouTube, and Spotify. Take care.
You've been tuning into Time is Not on Your Side with your host, board-certified litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.